This Honorable Court of Appeals of Tennessee is now in session.
Good morning. Before we have Mr. Hibner call the case, just to point out a couple of things. If we should have any technology problems, we'll just take a pause and we'll resolve them and work through them and then pick back up. Things are running very smoothly, so we don't anticipate any. Mr. Hibner, if you will call the case, please.
Kimberly Ann McGrath versus Melissa Powers Hester et al.
We'll hear from the appellant.
Good morning, Your Honors. My name is Donald Caparello of the Nashville Bar. I represent Kimberly McGrath, who's trying to recover life insurance proceeds for her two children. I'd like to reserve 3 minutes for rebuttal.
That'll be fine.
Your Honor, this case is here because the father, in this case, who's now deceased, Brian Hester, defied the trial court's order requiring him to maintain life insurance for the children. In 2005, when he was married to my client, he had a $500,000 policy, and she was the beneficiary. In 2009, when they got divorced, they entered an MDA, which the trial court entered as an order, a final decree order, requiring him to have at least a $300,000 policy. And the timing, that policy was required to stay in force as long as there was a child support obligation. And the father was the only one with the child support obligation. Now, they amended the parenting plan 3 more times, but every time the $300,000 minimum child support obligation remained the same. In 2011, Mr. Hester remarried Melissa Hester. And in 2014, he secretly changed the beneficiary to this same life insurance policy that was identified at the time they got divorced to his new wife, Miss Hester. Nobody, the children didn't know, Mrs. McGrath didn't know that he had changed it. When he died in September of 2018, it was then determined that the beneficiary had been changed. So then she filed suit to try and recover the proceeds. The trial court found, following very well-established law, that the children were, because of the MDA that was made into a final degree, had a vested interest in the life insurance policy. But the trial court then went a different route than all the other cases that we cited in our brief and said that the only amount that the children had a vested interest in was the amount of child support that would be due and owing before they turned 18. Your Honor, that is not what the language says. It just says how long the life insurance policy is supposed to remain in force. It in no way breaks down how much is owed. It should be just the full amount of the life insurance policy. And there's a long list of cases, we've cited Holt in the Holbert case, that basically stand for the proposition that it's the full amount that should be paid. The Holbert case says that when there's any dispute about this, and I'll read the quote because it's really helpful. We believe that in doubtful cases, the doubt should be resolved against the one who has changed the beneficiary in defiance of a court order. Now, this is not a doubtful case at all, we submit, but to the extent that you have any questions about what the life insurance provision of the parenting plan means, you must resolve the doubt against the person who defied the court order and changed the beneficiary. If he had not changed the beneficiary, there would be no issue, there'd be no lawsuit, and the children would get the full amount of the proceeds. We're only here because he defied a court order. Now, Ms. Hester has argued that no, the language of the insurance, the life insurance provision in the parenting plan, which never really essentially changed, actually just secures the amount of the child support due and owing. But that doesn't make sense for the following reasons. Both husband and wife had an obligation under that to secure the life insurance. The wife had no child support obligation at all in this case. Had the wife died, under their interpretation of this agreement, the wife would have no child support obligation. Therefore, the life insurance policy would be meaningless and the children would get nothing. This mutual life insurance obligation must mean that it is the full amount of the policy that goes to the children when the person when the person dies. Now, the defendants, Ms. Hester has made the argument that, well, the wife didn't comply with the provision either. However, that was an issue raised in the trial court in the form of an unclean hands argument. The trial court denied that argument, finding that it indeed was a vested right in the children. And more importantly, that issue is not before Your Honor because they didn't raise it in their appeal. They've not raised the unclean hands argument at all. So they can't try and balance the equities between the spouses. More importantly, the balance is not between the spouses. The balance is between the father and the children, because the mother is before the court solely to try and collect the child support for the children, not for herself.
That's what, I mean, as I understand it, the only issue left to be decided before us is whether or not the trial court erred as to limiting the amount to the child support that would have been owed.
That's true, although there's also an issue of attorney's fees, should we prevail.
Yes.
So,
Caparella, I'm sorry to interrupt you, but let me ask you this. Let's assume that we didn't have stepmother and change of beneficiary in play, that the policy remained as the language of the MDA required, which is the mother as beneficiary to basically hold those funds as trustee for the benefit of the children. And let's say that father had died under those circumstances. Is it your position that given the language of the MDA, those children would be entitled to the entire 300, or would they be entitled to just the amount of child support with the mother making sure they have that as the trustee?
They would be entitled to the full amount. And we have an AOC form here. So that language, the AOC form language, has not been litigated as an AOC form. However, we have very similar language litigated before the form was required. And that in the Holt case and the Holbert case and others, that suggests that when there is a life insurance provision that says it stays in place until the child support obligation has been completed, that is just saying the timing, how long the life insurance policy should remain in force. It doesn't say to secure the child support obligation only. It doesn't say that secure only what is due and owing. And there, I cited in my brief websites that provide language for lawyers who want to have a different set of language that specifically says that the life insurance proceeds are not the full amount, but are limited in some way. Here, there is no limitation on it. And remember, the first word of this sentence is until the child support obligation has been completed. So that is a timing issue, how long the life insurance must remain in force. That's all that says, and that's all that means. Now, on the another thing that's also important to point out is that if the father had not changed the child support, the life insurance beneficiary, then there would be no issue here at all because the children get the full amount. And we know that the father knew he had this obligation because his lawyer wrote letters and he testified under oath that he still had this policy in place. And that shows a level of untruthfulness by the father because he knew he'd already changed the policy in 2014 when he testified in 2016 and his lawyer wrote in 2016 that he still had the policy in place for the children. This argument that it only means the proceeds are there to cover what is owed was never made by anybody up until the time that after he died and the lawyers came in now. If they had wanted that interpretation, they could have put that language in here and made it really clear because, and as one of the other cases cited in my brief says, if the language is not there to specifically say they don't get the full amount, why should we work hard to interpret it that way? Specifically when that would be in favor of the person who defied the court's order and changed the beneficiary in the first place. Now, on the attorney's fees question, we believe we're entitled to attorney's fees under two different theories. First of all, the MDA said that the prevailing party, if there's a dispute over the MDA or if there's a breach of the MDA, gets attorney's fees. And while my opponent has argued that has been set aside because they changed the parenting plan several times, they didn't change the MDA, which said attorney's fees are awarded to the prevailing party when you have to litigate about whether the MDA has been breached or the parenting plan has been breached or the parenting plan has not been followed. It's true that when they did the 2017 parenting plan language that required him to have this policy, that in that agreed order, they said that the parties will bear their own costs. But that agreed order, which is also in the record and cited in our brief, only relates to bearing their costs as it related to the petition to change the parenting plan, not to change the MDA. The MDA requiring attorney's fees to go to the prevailing party has never changed and is still in force. Yes, Your Honor?
Let me ask you a question here. I mean, the opposing party here was not a party to that MDA. Is that correct?
That's correct.
And you're asking the court to charge her with attorney fees under an agreement she didn't sign.
Well, there's also a second theory as to why.
First, let me ask you, is the answer to that question yes?
The answer is yes.
Okay.
And however, under the statute, which provides a cost shifting situation when there's a prevailing party, when you're trying to enforce a parenting plan, we provided examples in our reply brief of situations where the court has awarded attorney's fees against somebody other than the spouse when a third person has gotten involved in a divorce and has gotten crossways with the court and was not the prevailing party in litigating over a parenting plan. So there are a few examples where a party who's not a spouse has been held liable for an obligation that they were not a party to, but still were involved in litigation. So we do believe we have a right to get attorney's fees under that special things that's set forth in our reply brief. So lastly, Your Honor, we would ask that the court affirm the trial court finding that children have a vested interest in the life insurance proceeds, but reverse the trial court and find that they have a right to the entire $300,000 of life insurance proceeds, and also award attorney's fees at the trial court and appeal level. Thank you.
Thank you. You have your time for rebuttal. We'll hear from the appellee.
Thank you, Your Honor. May it please the court. My name is Sonia Wright, and along with Amy Farah and Amanda Moore, we represent the defendant in this matter, Melissa Hester. This is a case about what is equitable when neither party is abiding by the terms of a contract. As the appellants continue to say throughout their argument that we defied a court order, and it's not we, it's actually Ms. Hester's deceased husband. Both parties did that because every iteration of the MDA and the parenting plans, which the parenting plans is what was changed each time, each one of those provided that both parties would get insurance. And Ms. McGrath, the appellant, never did that. So both parties have defied the court's order. So this case is really about what is the equitable remedy. And the Chancery Court looked at that, and the court below found that the equitable remedy, when the children are entitled to a portion of the insurance proceeds, it found that the children are entitled to the portion of insurance proceeds that are necessary to secure the remaining child support obligations owed by the father, and quoted the language until the child support obligation has been completed, which is the language of the parenting plan that the parties agreed upon. Your Honors, contract law and case law both supports the ruling from the Chancery Court below. The plain language of the life insurance provision states that it's going to be until the child support obligation is completed. Additionally, the case law, even the case cited by Holt, all stand for the proposition that you must look at the insurance provision, read that provision, and determine what it is that is required under that policy. The Layton case is the most, the case that is the most relevant to this argument because the language of that insurance policy is very similar to the insurance policy provision that we have here. Both of them were tied to the child support obligation. This court should further find that the court properly found that the plaintiff is not entitled to attorney's fees. And as Judge Sweeney pointed out, most importantly, because she wasn't even a party to this contract that they're now trying to enforce upon her. We would ask that this court follow the Chancery Court's logic and find that the court properly ruled that the equitable remedy here is for it to be limited to the child support obligations that are still owed, and that it was within the court's discretion to determine that there were no attorney's fees that should be awarded in this case.
Counsel, let me ask you about that. Are you basing your argument solely on the equity? I mean, are you saying that the language may say one thing, but equity demands another?
No, Your Honor, I'm actually saying both. I'm saying the insurance policy itself, that provision states, and I quote it again, until the child support obligation is completed. So the court can look to that provision, which is what the chancellor did, but he also took it a step farther and said, but it's also an equitable remedy, and we're going to make sure that there's not a windfall in this case, and we're going to apply the factors in Layton and make, I'm sorry, go ahead, Your Honor.
No, go ahead. I'll wait till you finish.
And make sure that we're going to apply those factors and make sure that there's an equitable remedy. And I think that's another thing that's important here is the standard of review in a case such as this. And here, the chancellor has an equitable remedy that he's created, and it's an abuse of discretion. So unless this court finds that he somehow abused his discretion in making this finding, then the court should uphold that decision.
What do you do with the language that says each policy shall name the following as sole irrevocable primary beneficiary? And it's, you know, I guess, depending on which one you're looking at, I guess it says the other parent is trustee for the benefit of the children. I mean, if sole primary beneficiary, I mean, what does that mean?
I think, Your Honor, very good question. It means that he should have had her listed as the sole beneficiary on the policy, but then you have to read on in the contract. We can't just read that one sentence out of play. And the very next sentence states, until the child support obligation is completed. It's very clear here, and that's what the chancellor found, that reading the contract as a whole, that this provision was completely tied to child support. If they have one,
until the child support obligation has been completed comes before that statement. Doesn't come after it. It comes before that statement, at least from what I'm reading. It says each policy shall name the following as sole irrevocable primary beneficiary.
and Your Honor, if we look to the 2017 parenting plan, which I believe is the one that we have agreed would come into play here, it reads, both shall insure his or her life, and this is on the record, page 77. Both shall insure his or her own life in the minimum amount of $300,000 by whole or life term insurance until the child support obligation has been completed. I understand your question now, Your Honor, that the fact that that comes later. Each policy shall name, and that's why I said it has to be read together. The entire sentence has to be read together. So until the child support obligation has been completed, each policy shall name the child or the children as the sole irrevocable primary beneficiary. And reading that together is what the Chancery Court did to find that the child support obligation is directly tied to making them the primary beneficiary. There was no extension of this or continuous obligation like in the Holt case, where Holt said it's not just child support, but also we're going to look ahead and say, we're also going to set up a trust for this child so that if something happens before they reach the age of 25, we're going to give them something. And if something happens after 25, we're going to give them something. That was a continuous obligation that the court identified, and that's very distinguishable from the facts of our case, because here it is only tied to until the child support obligation has been completed. And that is a similar language, again, from what is the language in Layton, which the language in Layton is so long as he has a child support obligation for them. And the court, in looking at that provision, stated that because it is tied to the child support obligation, we have to look at the other factors. And the court said that you have to receive a credit for any payments that were going to be made, and that it was limited to the child support obligations that were owing. Just like the Layton case, we have children with a vested interest. Just like the Layton case, we have language of the parties' agreement that's directly tied to child support and doesn't extend it or make it a continuous provision. Just like Layton, the child's interest cannot exceed the child support obligation. In the Hinkle case, it talked about this as well, of a policy that was in place at the time of a divorce, and then what would happen later when that policy ended, but there was a larger policy. And the court says, we're not going to extend it to that additional amount. We're going to go back and look at what would have happened at the time that the obligation was vested. That's very similar again to our facts here. The cases cited by both parties make clear that the amount of the vested interest depends upon the language contained in the agreement. And as I stated, Holt even quotes the language. Clear language of the divorce decree contemplates a continuous obligation. Here we don't have that.
Counsel, let me ask you, if you know, at the time this was first provision, I guess in 2010, what was the total, assuming father's child support payment stayed the same as was set out in that provision? What would do you know what the total amount of his child support payments would have been from that time until the children aged out?
We actually had looked at that at one point, Your Honor, and that's cited in our response in the motion for summary judgment. And it was an amount that was about equal to the $300,000.
Okay. Do you remember what it was? Was it less than?
I believe it was a little bit less than, Your Honor, but I cannot say for certain on the numbers without doing them out. Mm-hmm.
That's fine.
But that again supports what I'm saying, is that was what the intent was. The intent was to have a life insurance policy, and it says minimum. It actually doesn't say what that amount should be. It says a minimum amount of, and then they filled in that decision for their own. But that reasoning also ties back into the reason that they probably were tying that directly to the child support. They wanted to make sure if something happened to him, that child support would still be there for the children as they move forward. And Your Honors, this is not just talking about the two children in the divorce proceeding. We also have two children and a widow in this proceeding. And again, I think that the court can look at the equitable remedy and decide what to do with that. And I understand that appellant says that we have now waived our argument regarding unclean hands, but we did argue that in the court below, and that is part of the reasoning of the trial court order. And he specifically said that he wanted to make sure that Ms. McGrath did not receive anything from the insurance policies because she did have unclean hands. She had defied the court order, just like Mr. Hester had done. Your Honor, all of the cases cited look specifically to the language of the policy and then decide what the equitable remedy will be. None of them sway from that. And the only reason the Layton case is so important here is because it is the most similar to the language that we have in our form and in our parenting plan. Your Honor, we would ask that this trial court find that the Chancery Court properly found that that in Holt, it was money to be paid over the child upon his reaching the age of 25, and it was not linked to just the child support obligation as it was here in our case. Appellant mentions the website, divorcenet.com. We would submit that has no bearing on the facts of this case here. And it is notable that that's an attorney out of California, and that she helps you with separation agreements. But it's also of note here, the first sentence of that blog, which states, many couples choose to secure their support obligations through life insurance. And that's exactly what happened here. They wanted to make sure that the parties were protected, the children were protected, should something happen to the parents. And they tied it directly to the child support payments. The plaintiff or the appellants also make the argument that there's 4 elements that are created in their reply brief and talk about those. There's no case that says we look at these 4 elements. This is something that the appellant has created. What the courts or what the case law states is that we've got to look at the law, we've got to interpret what the law is, and we've got to make an equitable remedy that supports that. And that's what the chancellor did. Similarly, the public policy argument fails. If Ms. McGrath were the one to pass away, Surely it's understood that because the children live in her home, she supports them financially right now. Your Honor, our position would be if she had obtained the life insurance like she should have under the court's order, that had she passed away, he would have also been entitled to child support payments or obligations, because the child support payments wouldn't have been completed until the child turned 18. Just like if there had been a change in custody and the father had begun having the children and he was the primary custodian, there would have been a change, and that is what that provision provided for. It allowed for flexibility there so that both parties would be responsible for the child support should that time come. Your Honor, the Chancery Court further found properly that no attorney fees were appropriate in this case. As Judge Sweeney pointed out, they are asking you to enforce a contract against Ms. Hester that she didn't sign. She was not a party to the MDA. There's no basis to bind her to it. It states that the parties are Mr. Hester and Ms. McGrath. She's not a party at fault. The agreement did not bind the heirs as successors are assigned. And she did not bring this action, nor did she intervene in this action. She is simply the widow of Mr. Hester. The statute 365103 is a discretionary statute, and the court can choose to award fees, but did not do so in this case other than to award cost in the trial court below. The taxation of cost in equity cases is largely in the Chancellor's discretion, which will not be disrupted except for manifest and palpable abuse. Again, Your Honor, there's nothing here to show that the Chancellor abused his discretion in looking at that statute and making a discretionary decision that he was not going to award attorney's fees in this case. Your Honors, the decision regarding a vested interest is an equitable remedy made by the Chancellor in his role as a court of equity. The abuse of discretion standard applies, and the Chancellor's decision should not be overturned unless abuse has been shown, which none has ever even been argued in this case. As we've stated, the attorney's fees provision is with the MDA. Ms. Hester was not a party to it, so the court properly found that as she was not a party, she should not be bound by the MDA's attorney fee provision. Similarly, Tennessee Code 365103 says that fees may be awarded. The trial court in this decision decided not to award those fees to the party. Instead, he awarded the cost and allowed for the appellant to have those costs at the Chancery Court level. Your Honors, again, this is equitable remedy. It's abuse of discretion. The court has to make a decision that the Chancery Court below did something to abuse that power. They must look to the conscientious judgment of the Chancellor, make sure that it was consistent with the facts, and take all of this into account in looking at the applicable law. We would ask that you affirm the decision of the Chancery Court with regards to the equitable remedy that it found, and also to affirm the decision of the Chancery Court that no attorney's fees are awarded in this situation. Thank you, Your Honors.
Thank you. We'll hear from the appellant rebuttal.
Thank you, Your Honor. The trial court ruled on summary judgment, finding no material issues of fact, and the opposing counsel has not identified any material issues of fact. The only issue before this court is, what does the life insurance provision in the parenting plan mean? That's an issue of law. It's not an issue of fact. So there's not an abuse of discretion standard review. We think it's a de novo standard review, and you can reverse if you think the trial court erred as a matter of law. Next, the Layton case is not on point for the following three reasons. In the Layton case, the insurance provision does not even list a specific amount of life insurance, while in this case, the insurance provision specifies at least $300,000. It doesn't even require that the named beneficiary be the sole beneficiary. And as Your Honor pointed out, this provision lists the children as the sole irrevocable primary beneficiary, with the mother as trustee. And thirdly, the Layton case doesn't remand to determine how much child support is due and owing and set the life insurance proceeds to that amount. It doesn't even address the issue before this court. So the Layton case is not on point. We submit the Holt versus Holt case and its progeny are controlling in this case. The language of the life insurance provision that this court is required to interpret, even though the parenting plan was amended 4 times, the operative language never changed. In 2009, counsel said that the amount of child support that was due and owing was approximately $300,000. The parties never chose to change it. They never chose to change the language to say a graduated amount will go down every 3 years. They never said that we want the life insurance proceeds to secure the amount of the obligation, as opposed to the provision just saying how long the obligation to keep the life insurance policy in place lasted. It just says until the child support obligation has been completed. That's all that says, is how long the life insurance policy must kept in force. For you to interpret that language, that clear language that doesn't say what they want it to say, you're going to have to resolve the doubt in their favor. And the father in this case defied that. He's the only one that had that policy. He was the only one that had a child support obligation, and he defied the court order. And the Holbert versus Holbert case said very clearly that when there's a doubt, you resolve it against the person that died, the person that defied the order. The mother in this case didn't die, so it's moot what would happen under those circumstances. But we would submit that we agree that if she had died, the children would have got her life insurance policy proceeds, because the joint provision doesn't require the children only to get what's left due and owing. We ask that the trial court be reversed and the children get a full amount of the policy, and that you also award attorney's fees. Thank you.
Thanks to counsel for both sides. We appreciate your briefs and your oral argument this morning. I think you've made the issues and your client's positions clear. Mr. Hivner, if you would, recess court until 1 o'clock this afternoon, if I've got the times right.
Yes, sir. This honorable court is now in recess until 1 p.m.
Thank you very much.
Thank you.
Your honors.
Thank you.
Thank you.